The history of the H-1B visa, Part 3, will cover American Competitiveness in the 21st Century Act, AC21. There were a number of significant changes made to immigration benefits once the AC21 was signed into law. The AC21 is considered by many to be a continuation of the ACWIA from the history of the H-1B visa Part 2 discussed on the H1B Guy last Thursday. Let's take a look at the most significant changes from the AC21. October 17, 2000. Signed into law by President Bill Clinton, the American Competitiveness in the 21st Century Act, AC21, resulted in several significant modifications to the H-1B visa. The first of which increased the fiscal quota allotment to $195,000 for the years 2001, 2002, and 2003 due to a significant backlog. The second installment was that the H-1B visa holders working for nonprofit organizations, included research, education, and government institutions, became exempt for the HCAP quota. Prior to the AC21, all H-1B visas were counted against the fiscal year quota. One stipulation was that if the H-1B visa was working under an exempt H-1B and switched to a non-exempt employer, that the H-1B would be subject to the HCAP. So this basically means that if the H-1 was working for an exempt employer, transferred to a non-exempt, then they would be subject to the cap. The AC21 included language that allowed for H-1B change of employers, or what we refer to as transfers, for those applying for an extension would not account against the HCAP. This had a significant impact for existing H-1Bs seeking to change jobs without a waiting period, and new HCAP cases which could have multiple filings, but only one would be counted once in the cap going forward. There were also modifications to the employment-based categories EB1, EB2, and EB3 that were put into law with the Immigration Act of 1990. It included language referring to per-country ceilings based on country of chargeability, or, quote, country of origin, and made unused slots from a given country available in the general use category. The last part of Section 104 was also instrumental in shaping the H-1B visa today, based on the H-1B employee having a pending or approved I-140 and waiting on their priority date to become current, which allowed for the extension of the H-1B in 3-year increments until their adjustment of status was improved. Increased portability allowed for an H-1B transfer to a new employer and begin working before the petition was approved. This is what is commonly referred to as a confirmation of receipt or receipt notice. The H-1B employee could continue to work for up to 240 days until the petition had been adjudicated. This is also referred to as the AC21-I-145 portability, or, quote, similar occupational classifications for job portability. Those individuals that were facing long adjudications of a pending I-140 for more than 365 days would be allowed 1-year extensions, as well as individuals with a pending I-45 for more than 180 days would be allowed to change employers and jobs without negating their previously approved I-140. Very significant step here. And finally, the $500 application fee put into law by the ACWIA was increased to a $1,000 application fee with details on how the funds from the application fees would be allocated. Here's where we see the continuation and increase in the fee-based model under INS, which USCIS has continued to impose even today. What do you think about the AC21's impact on the current U.S. immigration benefits relating to the H-1B visa and employment-based residency? For more on the history of the H-1B visa, please check out Part 1 and Part 2 on the H1BGuy.com and on the H1B Guy YouTube channel. The history of the H-1B visa Part 4 will be released next Monday and will cover trade agreements between the U.S. and Singapore and the U.S. and Chile and the H-1B Visa Reform Act of 2004. And as a reminder, let's go ahead and set your calendars for Wednesday at 11 a.m. for the first installment of the H1BGuyLive.com. A link for the live stream will be in the description below. I'll be covering H1B status issues, H1B reform, third-party best practices, recent H1B lawsuits, protests and opinions on S386, and hopefully a few Q&As if anyone shows up. As always, please like and subscribe and give this video a thumbs up. The H1B Guy, your global source for all things H1B.